welcome Shannon Galon, and thanks for joining us today to talk about wills and estates. So when we're in real estate, one of the things I think every realtor should be talking to their clients about, we paid extra for this. Do you believe that? Out. I know, must be just it's more fun than a barrel of monkeys in your office. Every day. Oh.
Yeah, it's green.
We good now?
Are we paused?
No.
Okay, so we're back. Everybody can hear Shannon?
Hello?
If you can hear Shannon,
Hi.
wave, because the camera works two ways. Oh, Jeff said he can hear her, so that's good. So one of the things when we're talking with our buyers, the importance that they should have, even maybe before they actually make the purchase, is really looking at some estate planning.
Absolutely.
Because you just never know. One of my realtors had a case a couple of years ago. A young couple, not yet married, took possession of their home on Friday. They went away for a family vacation, and he actually drowned on the weekend, intestate.
Right.
Which caused huge problems with the home, everything else. So, and of course, not just the crushing loss of the person most close to her in her life, but all the things she then had to deal with, like a mortgage on her own, all of these things, as they dealt with all those matters. So when is the right time, and kind of let's talk a little bit about that process.
Now is right. Right now is the right time. Everyone needs a will. I can't emphasize that enough. What's unique about realtors is that they are exposed to the general public. Most in a very like most people purchase a home, right?
Yes.
So they're exposed to a whole host of people, and in reality, everyone needs a will. So whether you are a blended family situation where you have two people who are now married and have children of their own, how do you want the house to be dealt with? Where do you want your estate to go? It's not necessarily what you may think may happen if you just let legislation step in, which is what would happen if you didn't have a will. Going back to the situation that you're mentioning about the partner who wasn't married and her losing her common law partner, it's an issue. If there was an old will at play and wasn't updated, now we have a situation where the deceased would have wanted something but didn't communicate it via will, and instead you're left with a mess. You have situations even with first buyers,
yeah,
where even that individual, say you don't have children or a partner, but you don't get along very well with your parents. Well, if you let yourself die without a will, then your parents are going to be benefiting from your estate. You may not want that. A lot of times couples, you first have your first children. Who's the guardian for your children? If you don't set up a will, you can't choose. You may not want your brother to take care of your children. Well, you won't have that choice if your brother is the one that steps up. Divorce scenarios, by the way, so if you just got divorced.
Hopefully your divorce lawyer would say, what's your will say, and let's get that sucker changed.
Absolutely. I mean, the legislation has changed now so that if you get a divorce and you don't update your will, your ex-spouse is effectively written out of your will, but then you come into a situation of you're essentially dying without a will. So updating things like your RSPs, life insurance, tax-free savings accounts so that your ex is not getting these assets, because a lot of people don't understand that those assets aren't even covered by a will. It's covered in if you have a beneficiary listed within it.
Yes.
It could be covered by the will, but it sort of depends on what you've done and what you've set up. So not only is it important to have a will, it's also important to have that chat with a wills and estates lawyer who can help guide you through this. It's so important because, like you were just mentioning with that partner and her spouse dying, we just never know. what's certain in life is we all are going to go. We just don't know when we're going to go.
Or how quickly.
Or how quickly,
It
exactly.
can happen in an instant.
For sure.
Well, and I think of the estate planning when Kathy, my wife, and I got married, and I was able, she brought 2 beautiful girls into my life, but there were things that we had to consider. So we put together an estate plan at that time, and then we fast forwarded to a couple of years ago, and we suddenly realized our youngest son was now adult of age. Everything had changed. It was still in there that Kathy's brother, all of these things that were so far out of date. And we went to the lawyer we used at that time and went through a really interesting process, because it was exactly what you were talking about. Just not all the things we consider that we need to put in the will, but what are the other things? And if you've already set it up that any of your investments go direct and are dealt with outside of the estate, what the tax advantages, different things are for the people that will inherit. So there are a lot of things to consider, but we went in and basically, although what we had planned to do didn't really change, it was just all cleaned up. We have a new executrix in on the estate. They have copies of everything. They're well informed. I have no worries that if, God forbid something happened and we both went at the exact same time, we don't have to worry, because everything's dealt with. Our children are well aware of what's going on, importance of having that conversation with them. Having been an executor twice, it's an thankless job.
Oh, absolutely.
And the better we can communicate what's going to happen to people, I think goes a long way to those
David,
issues that can come up within a family.
100%. And David, you're hitting it right on the nail there. Honestly, when I have clients come see me, my biggest thing I can say to anyone is communicate. Communicate what you can now while you're alive and you're able to. For some people, for some reason, people seem to want to keep their will and what they're doing in their planning process a secret. I get it. People don't like talking about death. It's not a very pleasant topic to talk about, but again, that's a certainty in everyone's life. So chat with people now. Chat about who you want to be your executor, because as you were mentioning, it's a big job. Ideally, someone in Alberta, someone who has some wherewithal with them, is going to be able to be reasonable among the beneficiaries and be even-handed among everyone. Chat with who you want to have, as guardians
Prepare
of your kids. Absolutely. Talk to them about what they would want of your personal effects and household goods. I've seen people fight over a stamp collection that is worth literally nothing. And it's not necessarily to do about the stamp collection. It's just there's been animosity in the group, or, the state hasn't been distributed in a way that, it should be distributed. Chat with people now, because you would be surprised as to what comes out of the woodwork. Please don't hide your will. It doesn't do anyone any good if you hide it underneath your bed frame and your estate's distributed or dealt with, and all of a sudden, lo and behold, there's a will. This has happened. Please don't do that. Make sure you communicate where that will is. And on top of that, which is sort of a sidebar, you should also be looking at getting an enduring power of attorney and personal directive done. So for those of you who don't know what that is, an enduring power of attorney deals with the situation where you don't have capacity and you're appointing someone called your attorney, which is not me. It's someone who you know and trust to deal with your financial affairs. And the personal directive is where you're appointing someone to handle your medical care. Both really good documents to have in place. Sort of like insurance. I can't guarantee you that you'll ever need them, but it is worthwhile to get all this done. And really, you're not doing this for yourself. You're doing these documents for the people you're leaving behind. So get good advice. Advise your clients when you meet these people, because it is super important that everyone is informed and gets these documents done.
Well, and in our case, all of our children are aware. They know who's doing what. They also know what our wishes are when it comes to personal directives.
Oh, perfect.
So and thinking further ahead, if they got into that situation, you don't ever want them to feel that guilt about doing what you asked them to do.
Absolutely.
When they have to say, pull the plug, do whatever you want to call it, flip the switch. But if that was your personal wish and you didn't want to be left in that state, give them the permission now to do that so
I
they know they're doing what you want. I think that's critical.
I agree with you. I would say by and large, most people don't want to be a burden on someone else, but it is very difficult for someone to let go of someone. But if you have these conversations now, you're right, it does alleviate a lot of guilt from your children, your spouse, whoever is doing this for you. And I can't emphasize enough on personal directives. That conversation about the medical situation, the hospitals have a tendency to default to your agent an awful lot, even though there might be stuff in my documents. So it's up to the agent to ultimately make that decision in a large, most of these scenarios. So as you were saying, have these conversations now.
Okay, so sometimes, and when we run into this where it's happened to a client and they're an executor now and they come forward, what are some of the critical pieces of advice we can give them? Because quite often they reach out fairly early in the process, sometimes even before the funeral's been completed. What am I going to do? I know I'm this. So we have to help direct them on what to do, where they can move through. They're obviously going to work with the lawyer that will be handling the estate,
Right.
and making sure those communication lines are open. Well, what are kind of critical first steps that we should be giving them?
Well, first of all, obviously, the remains, that's the number one
Yes.
concern. You do have to get rid of the remains. You should start canceling things to the extent that you're able to cancel things. You don't want your estate assets to keep on being dwindled. And obviously contact a lawyer as well. You do have to approach the bank, start that process there. The banks, it actually depends on the bank. It depends on the branch. It depends on whether the sun's in the sky.
Yes, absolutely.
Yeah, it's so variable as to how they're going to react. If you have a good relationship with the bank, it might move more smoothly. But having a will in place at the outset is going to make that executor's life so much easier, because at least, if nothing else, even though it hasn't gone through a probate process quite at that stage, the bank has some kind of assurance that this is the person they should be dealing with. So that one, because otherwise, how are they supposed to know someone passes away, an estranged child now is going to the bank and trying to become the executor of someone's estate, right? So again, having that will in place. But for executors, it's just a matter of making sure the estate assets are secured. So looking at insurance, making sure changing locks to the house, so that people don't go into the house. Because once the executor is the executor, they could potentially be liable for any estate asset that goes is dissipated, or something happens to it. So someone vandalizes the home. That's an issue, right? Executors are also required to make sure that all debts are paid out. That's the first thing that comes out of any estate. So make sure that all the creditors are accounted for, which, like, as I was saying, make sure everything's canceled as well, so it doesn't keep on dissipating estate assets.
Okay. And one of the things, having done it twice, I found was so important was making sure you have multiple copies of, in Ontario, where I did it both times, it's called a death certificate. We call it something slightly different here. Funeral director's certificate or something?
There is a death certificate from the Government of Canada, or Government of Alberta, but you can actually get away with the funeral statement. Funeral
and it allows you to start some of the processes. But everywhere you go, everybody wants one, and they don't want a copy. They want a certified true copy. Scans, photocopies usually are not acceptable.
No.
So, and when we talk about it in real estate, we kind of lay it out. You need to get a hold of the estate lawyer, get the will, the probate started as quick as possible. Now, we always get this question quite often from clients is, do we have to wait till probate is issued to put the home on the marketplace? And we know through RECA and CREB rules that we can, with certain disclosures. It'll be subject to probate. We have to put those conditions in. But what do you feel is maybe the better process to do?
It's variable. To be honest, you can sell the property. Now, the surrogate court, which is where probate applications are processed, recently changed this last year because they were getting way too many expedited grants. They didn't like that, so they've kind of stopped that on some level. So we can still sell the property because the court is aware that the house is oftentimes the most significant asset that anyone really has, and there's a mortgage attached to it, etc. So they know that selling the house is an important process. If you can wait to sell it, then in some ways it's almost better to wait for the full grant of probate, because even though I can get a limited grant which would allow you to sell the property, it delays the entire probate process because I now have to resubmit another application. It just delays things. So if you can wait, great, but I understand that sometimes you can't for whatever reason. So it really depends on the scenario and sort of what's going on.
Okay,
Yeah.
that's good. I didn't realize they had made that change in the past year, so great information. What else should we be talking to our clients about?
Well, I mean, again, what would you want done with your remains? I know it sounds crazy, maybe not to you, but people are very, very particular as to what happens to, you know, their ashes. I've had people wanting to be shot out of cannons. Like, I hear it all, you know.
Sorry, I don't mean to laugh at death, but
you know,
I have a
what?
few
No
relatives
judgment,
I'd be
no
happy to shoot out of a
judgment.
cannon. I mean,
No, I
what a
just-
great
I
way
don't
to, you know,
know.
maybe launch them into the afterlife.
Right, exactly, right? I think that's what this gentleman was thinking, which is
Yeah.
fine. If you can
I
arrange
just have
that,
to ask, is he
great.
related to Jeff in any shape? Just curious, because I could see Jeff doing that and thinking, this'll be fun.
Oh, yeah, no, but I mean, I can definitely see that. You know, guardianship of pets, when you want the
Yeah.
children to receive their share of the estate, legally in Alberta it's 18, but it doesn't need to be 18. Money can be placed in trust, and then the trustee, who is normally your executor, is able to dip into the trust for things like schooling, worthwhile travel, volunteer experiences, that sort of thing. But really think about how mature your children are and whether or not you do want them having all that money at 18.
At 18.
Yeah. So things like that, you know. Yeah.
Excellent. So I think the key takeaways here are, one, immediately empathize. Two, have they ever done this before? Are they aware? How much information did they get from the person that passed away? And number one to me is you get to the lawyer with the will and start the probate process and the bank.
Yeah.
Because both times for us that was critical, because you need to start the processes. It doesn't go away.
No.
And it sometimes, if someone died and you've got mortgages, how much money is available to keep paying the mortgage? And banks will be patient for a period of time, but they have foreclosed on properties where the person has passed away, and that eats up huge chunks.
It does. Yeah.
And at the end of the day, the bank is responsible for the money they lent, so they have to safeguard their people. We think of them as the big evil person, but they're doing their job, and if we do ours correctly, we can work with them and usually alleviate that.
For sure, and a large part of that, and that's actually a really good point, a large part of that is picking the appropriate executor.
Yeah.
Someone who is able to administer your estate in a timely fashion, because it's critical. It's very, very important.
And it's not a quick process.
No.
When you think about filing, you know, if someone passes away now, we still have to file their taxes from this year. And I know in both of mine, one was 18 months and one was 2 years to final closing of the full estate.
Taxes is typically or oftentimes the longest thing. The CRA is very, very slow at processing these things. The executor should not distribute the entire estate until they get the clearance certificate. Get that clearance certificate from the CRA. Do not owe the government taxes, because the executor will be personally liable for any money that is outstanding.
Yep. Well, like they say, there's only two things you can never escape: death and
The
taxes.
man, yep.
So the CRA will always make sure they twist out every last dime.
For sure.
So I want to thank you, Shannon. You're an awesome guest.
Oh, well, thank you.
First
very much
time
for
on.
having
I
me.
know you were a little nervous, but if anybody wants to, please look Shannon up on Jeff Kahane's law site and send her a thank you for coming out today and helping us. We'd appreciate it.